Good morning, everyone, and welcome to the Appeals Court. I am Chief Justice Amy Blake. To my right is Justice William Meade. To my left is Justice Gloria Tan. We are the panel that will be hearing the 6 cases on the list in this session today. I know that most of you have been here before, but just a few reminders. Each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your materials, so our suggestion is that you get right to your arguments. With that, I will call the first case, Albert Alexander, MD versus BAYSTATE Health, Inc., and another, docket number 25P329. Counsel, good morning.
Good morning. May it please the Court, I'm Tanny Saperstein for the appellant, Dr. Alexander. The issue in this case, Your Honors, is the broad application of the medical peer review privilege, which was enacted in 1986 to deal with the medical malpractice crisis. The problem is that this is being applied wholesale to cases involving healthcare whistleblowers. And what is happening is that retaliatory discipline is being imposed, as in this case, when the purported conduct does not actually implicate patient care or medical malpractice, for that matter.
So you just made a huge leap. How do we get to that this is retaliatory?
That's a very good question, Your Honor. And unfortunately, given the limited amount, in fact, the no discovery to which we were entitled, it's almost impossible to prove retaliation. The jury came back and found that Dr. Alexander had engaged in protected conduct, but did not find retaliation. And the question, quite frankly, for this court, and there are no published appellate decisions on this, is how does a whistleblower obtain evidence of retaliation when access to the disciplinary proceedings, which are in fact retaliatory, is completely denied?
Well, you have
in this
the
case,
names,
we got nothing. I'm sorry, Your Honor.
Didn't you have the names of the members of the peer review committee, and there could have been depositions, right, of those witnesses?
But we were only allowed to question them as to what they actually observed, which was nothing, because they weren't involved in the incidents that occurred. They weren't on the premises seeing purportedly how Dr. Alexander conducted himself. We were not allowed to get any of the underlying documents. Quite frankly, I represented Dr. Alexander at the disciplinary hearing. I couldn't use the stuff that I had in my possession. It was purportedly protected by peer review.
But can both things be true? Could he have had disciplinary issues and be a whistleblower?
Yes.
Okay. So what you're asking us to do, well, you're asking us to make new law, are you not?
No, actually, Your Honor, I'm not asking you to make new law. So what I'm asking this court to do is apply the law as it's been interpreted in a narrow stance. As I was saying, the healthcare whistleblower statute was enacted to deal with medical malpractice, perceived medical malpractice in the Commonwealth. Most of the reported healthcare whistleblower cases do not involve medical malpractice. And there's no dispute at all that the facts and claims in this case don't involve medical malpractice or any other tort. In fact, part of the problem, Your Honors, is the dearth of appellate decisions which consider the application of the peer review privilege to healthcare whistleblower cases. And I'm going to do something I hardly ever do in an appellate argument. I'm actually going to jump ahead for one moment to the one case, sort of case, that did consider the application of the medical peer review privilege to healthcare whistleblower cases, and that was Zappala.
Sopranos?
That was, no, it was a sort of appellate case. This was Zappala versus Stewart, and that physician was disciplined similar to Dr. Alexander for behavior and conduct, not for the way patients were taken care of or for medical malpractice issues.
So that's not an appellate decision, right?
No, it's not, Your Honor. But
so can we talk about Vranos then? Does that case help you or hurt you?
Vranos?
Yes.
Well, that's not one that I was going to talk about today, but
well, but it's in your brief at 17, so I assumed you'd be ready to talk about it. If not, I can move on.
No, I read it, but that
follow
wasn't.
up on the Chief's question, though, Vranos, doesn't the court say that they recognize that the exception, there has to be a good faith, right? And good faith is construed narrowly, correct, to preserve really the purposes and the pretty high bar of the whole idea behind the peer review privilege, correct? Which is to promote candor, right, and confidentiality. And there has to, in order to pierce that privilege, there has to be a showing. Was that made here?
Well, so in Vranos, which is on page 17 of my brief, that actually dealt with a tort, that dealt with defamation, that didn't deal with a healthcare whistleblower case.
Still, though, it's the same. Isn't it a similar sort of analysis that we can make as to what showing needs to be made to pierce that privilege?
Well, not necessarily, because I actually think that the healthcare whistleblower statute, I guess the bottom line is, if healthcare providers who are healthcare whistleblowers are prevented from accessing any peer review materials, which is what happened in this case, as opposed to Pardo, which I can get to in a minute, how do you prove retaliation? And if you don't prove retaliation, then you don't get the protection of the healthcare whistleblower. In the Vranos case, as I said, it was a defamation case, and in this case, if you want to look for the lack of good faith in the peer review process, which was actually noted by both Judge Goodwin when she denied the motion to dismiss, and Judge Callan when he denied the motion for summary judgment, we didn't even know who the complaining parties were in the first disciplinary hearing. They weren't called, they weren't identified, no examination, clearly, and no cross-examination. One would think that that would be an absence of good faith when you can't even confront the people who complained about you.
But doesn't the case law, I mean, isn't there, and they discussed this in Pardo, correct, that the focus has to be on the committee members' actions within that peer review committee process itself and not on any possible discriminatory reasons for initiating that review, correct?
That's true. And in Pardo, which I would have been very happy if the trial court had followed in this case, in Pardo, although the medical peer review privilege was applied in a limited extent, the Pardo court, well, the trial court, which the Supreme Judicial Court upheld, was ordered the defendant to release a significant amount of presumably protected documents, including written materials that triggered the concerns, comparator promotional files, residents' teaching evaluations, transcripts and other records of the staff review committee. There was no such order in this matter. So if you want to balance the medical peer review privilege and the protections of the healthcare whistleblower, perhaps what you do, what the trial court does, which happened in Zappala and happened in almost every case other than this one that I could find, you order the release for either in-camera review, or you do redacted documents, or you do both. And you have the court, which is actually what Pardo said. Pardo said, in each case, a judge must determine whether a medical peer review privilege exists. The judge must then, and only then, examine whether the privilege applies to a particular document. In this case, this is the first order that we're appealing, the motion to compel the denial. Judge Mason did not conduct an in-camera review, did not order the release of any documents. So even if you want to apply the law as it currently stands, Pardo should apply, and there should have been a review of the documents rather than just taking the defendant's representations that they were all protected by peer review. I just want to address the issue of the good faith, whether it was conducted in good faith. And there's clearly sufficient evidence, at least the first one was not conducted in good faith, since we didn't even know who the complainants were at the time. They weren't brought to the hearing. There was no examination. There was nothing. Dr. Alexander was a surgeon for 32 years. This is the first time he was disciplined in 32 years of practice. And again, the issues were interpersonal, like Zappala, and not the care of the patient.
Well, isn't there an argument to be made in one of those instances involved disrespectful and abusive treatment of a nurse, right, and staff who was trying to get his attention to sign off on, I think, a specimen in one instance, I think.
The consent form? That was the second one, Your Honor. The first one was actually Dr. Alexander was in surgery. And somebody, I actually forget the position of the person, I don't think it was a nurse, I think it was an assistant of some sort, kept calling him while he was in surgery, operating on someone else, to ask him repeated questions about his next surgery. A, he didn't have the file, so anything he could have given them would have been meaningless without looking at the file, and B, he was operating on someone several times. I'm sorry.
Didn't his behavior lead to the specimen being mislabeled?
Okay, so that was a different, that was the second part of the first discipline, I think.
But those incidents, I think you said they didn't have anything to do with patient care, but.
Well, I do, and actually Judge Callan found that as well. In fact, Judge Callan in his, let me answer your question first, Justice Meade, I'm sorry. That was an issue where prior to the surgery, Dr. Alexander had made determinations as to what needed to be taken, to be biopsied. Once he got into the surgery, it became apparent that there was something that that wasn't evident before that, so he took a second specimen. He was still in the middle of surgery when they were talking about labeling the specimen. When it was over and it went down mislabeled, he contacted the, I want to say for the person who looks at the stuff, I forgot the name right now, and they worked it out, and he said it was no problem. But it was literally, again, in the middle of surgery, something unexpected came up, and it was sent down with the wrong label. But again, we're talking 32 years, and there was literally nothing, no discipline until recently. And Judge Callan found that, that there was sufficient evidence, and that was in denying the motion for summary judgment. Judge Callan found that the discipline that was meted out to Dr. Alexander was disproportionate to similarly situated people. And if you look at page 26 of my addendum, he specifically refers to the testimony not of Dr. Alexander, but of other doctors. Dr. Albert testified that there were complaints about other physicians' behavior that were worse than Dr. Alexander's and didn't directly concern patient care, yet no other physician received similar discipline. And Dr. Duke stated during his entire tenure on the committee, no other physician, aside from Dr. Alexander, was ever disciplined. Again, the big question here, and we're not appealing a jury verdict, we're appealing the pretrial motions that gave rise to our inability to get what we needed to prove retaliation. So that would be Judge Mason's decision on the motion to compel, Judge Callan's decision on a protective order, and Judge Callan's decision on the motion in limine. And I just want to correct one thing very quickly. In the defendant's brief, they cited, they quoted Judge Callan, but they only quoted part of what he said, and it's on page 40 of their brief. And what they said was what a reasonable jury could find under certain factual circumstances. And they said that we erroneously claimed that the court determined that the factual circumstances underpinning the peer review did not implicate public health or safety. If you actually look at the full quote for Judge Callan, which is page 27 to 28 of the addendum, the part missing from my sister's brief is, based on these countering views, and because there is no allegation concerning direct risk to the patients, the court concludes that Dr. Alexander has shown that a reasonable jury could find that the peer review board did not have a reasonable belief that its action would restrict incompetent behavior or would protect patients. That's addendum page 28. So, and there was actually one other mistake that Judge Mason made when he denied our motion to compel. Judge Mason stated that Dr. Jabor, who initiated the disciplinary proceeding, was not part of the committee, the peer review committee, and in fact he was. It's undisputed that he was. No one denied that he was. So we have a person on the medical peer review committee initiating the action, and Dr. Jabor was one of the people to whom Dr. Alexander raised his complaints.
Do you agree one of the things that we have to do is to evaluate whether you are prejudiced by any of these pretrial rulings?
Absolutely, Your Honor.
But ordinarily, when to support that kind of argument, one puts in the entire transcript, and you did not, if I'm correct.
No, I didn't, because most of the...
How are we supposed to evaluate whether you're prejudiced by these pretrial rulings when we don't have a complete record?
That's a hard question to answer. Are you talking about putting in the whole trial transcript?
The transcript of all the relevant proceedings. You put in excerpts.
Well, actually, we both put in excerpts. I don't think the decisions themselves can lead this court to determine.
We don't have to weigh them again or evaluate them against the evidence that was provided at trial?
Were you talking about, and I apologize, we are appealing 3 pretrial motions. So are you talking about the hearings of those motions, or are you talking about the entire trial?
Trial.
No, I don't think you need that, Your Honor, quite frankly, because, again, whatever was testified to, and let's assume, for purposes of this argument, that BAYSTATE's witnesses said, yes, it impacts patient care, and yes, we did this, and no, we weren't discriminating, we're retaliating. How would I possibly impeach that testimony if I don't have the documents that impeach it?
Yeah, but there may have been other evidence that came in at trial that made that not matter. But we're never going to know.
That's true, but I actually think that based on what we've submitted, which is the rulings and the law, and the fact that, quite frankly, this is not a typical medical peer review malpractice complaint. If I could just close.
You will have to leave it there, counsel. Thank you very much.
Can I just say one thing in closing?
No, counsel, your time has expired.
Okay, thank you.
Attorney Zuckerman.
Thank you, Your Honor. Chief Justice, members of the panel, may it please the court. Your Honors, Dr. Alexander's case does not actually raise a new issue.
Before you get there, I don't think you cross-appealed. I'm confused. Did you just give us another basis for affirmance?
What we did, Your Honor, was to say, in essence, if you were to reverse and remand, we would be seeking a ruling on a separate issue where we believe there was a plain error of law regarding the...
Do you think you cross-appealed?
We do, Your Honor.
Okay. I'll have to check the docket. You can continue with your argument.
Thank you, Your Honor. Your Honor, Dr. Alexander has not identified a statutory conflict. What he's looking for is just a broader exception to the peer review privilege. And the Supreme Judicial Court has been clear that this is a narrow exception with a high bar. Litigants have come before the courts in Massachusetts many times arguing that they have been unfairly prejudiced by their inability to break through the medical peer review privilege. And the answer from the court, again and again, has been that for public policy reasons, the privilege is to be broadly construed, and that only a single narrow exception for lack of good faith in the proceedings is to be recognized.
And how does one establish bad faith without having any access to the materials?
Your Honor, as one of the justices, as you previously noted, there is the opportunity to examine the members of the panel regarding any pre-existing biases.
And I'm sorry to interrupt, but were that to occur, wouldn't they just invoke the privilege that the judge granted them at trial?
The privilege, Your Honor, applies to any question that went into the content of the proceedings, but not, Your Honor, to the disposition, biases, prejudices, or other opinions they brought into the proceeding. They can walk up to the line in answering questions, but can't cross the line into the content of the proceedings, either what was submitted in the proceedings or what the deliberations or voting were. But they're able, for example...
Well, I can understand the deliberations or at the very least voting, but why not let it be examined in camera, let's say?
Because, Your Honor, the courts have been clear that this privilege, because of the strong public policy of allowing the medical profession to self-regulate and self-scrutinize.
I totally understand the public policy. It makes perfect sense. But how does a plaintiff show bad faith?
Certainly, Your Honor. The plaintiff could show that the members of the panel had pre-existing biases against him. They could show that there was some deficiency in the process itself, i.e., for example, that the process itself was not convened for a legitimate reason. That's a new argument that Dr. Alexander is making on appeal. However, and there could have been, in this case, Dr. Alexander could have made the showing that the entire process was invoked for a retaliatory reason. It wouldn't have gotten him into the process in terms of evidence, but it could have convinced a jury that this process was a retaliatory action. He had the ability to plumb both the motives of the panel coming in and all of the underlying witnesses to the events for which the peer review committee was convened. And he was unable to prove to a jury that this process was invoked for a retaliatory reason rather than for a legitimate purpose of a medical peer review committee. He argues now on appeal that it was invoked for that purpose, but there was no evidence of that at trial. The record doesn't reflect that this was a retaliatory proceeding to punish Dr. Alexander for whistleblowing, but rather that it was convened for a legitimate purpose of a medical peer review committee.
What's your position on my question to your sister about being able to show prejudice without a full trial transcript?
Your Honor, I think it's difficult. I think the court would have benefited from the ability to see what the jury saw, which essentially was evidence that this proceeding existed for legitimate concerns regarding patient care and the influence that conduct like Dr. Alexander's could have on the care of patients, as well as upon other staff members, and not for any retaliatory purpose related to his whistleblowing activities. Sister counsel's correct. The jury did, in fact, conclude that he engaged in whistleblowing conduct, but they had a causation problem. They did not find that that conduct led to the actions taken by the medical peer review committee or the convening of that committee in the first place. Your Honors, many times, including in the Brenos case and the Pardo case, litigants have looked to the court for a broader exception to the peer review privilege, and often backed by strong public policy. In the Pardo case, the policy in question was anti-discrimination. There was a compelling public policy reason that the litigant needed to get inside the proceeding. And the court said, you may, as a litigant, suffer some hardship because we have to protect the strong public policy interests that are embodied in the peer review privilege. The court didn't allow an overriding of that by another compelling interest. Instead, it said litigants may sometimes suffer a disadvantage or even be unable to make their case due to the fact that this, for public policy reasons, is a process that enjoys broad and robust protection.
What's the closest case to this fact pattern that we have that's a published decision?
Probably Brenos, Your Honor. I think Brenos tracks almost every issue in this case. I understand Sister Counsel referred to it as a tort issue and therefore not on all fours, but essentially the policy reasons are the same. The policy reasons, beside not allowing someone's reputation to be unfairly impugned, are similar to the policy protecting a whistleblower. We have, in each instance, an individual who's saying their individual rights are being curtailed by their inability to break through the privilege, and the court says clearly that may sometimes be the case. Actually, going back to the Carr case, Your Honor, there's a very clear discussion of the fact that sometimes individuals, litigants' rights will have to yield to the public policy considerations that animate the peer review process. And that is a policy choice that the legislature has made. And essentially litigants are going to run into it, and they can only, if they can get through this narrow door created in the statute itself for a lack of good faith, that's the way in which they're going to be able to overcome it. Dr. Alexander had the opportunity to do so here. He was granted explicitly by the court the ability to depose members of the peer review committee. He was given the names of every witness to the underlying events and could have deposed all of the witnesses to the underlying events and could have attempted to make the case that the underlying events did not justify the discipline and that therefore this was evidence that the process had been used in a retaliatory manner or even convened in the first place in a retaliatory manner. And the jury's verdict tells us that he did not satisfactorily convince them that this was the case, that there had been a retaliatory motive for the invoking of the process or for the discipline which issued from the process. He doesn't need to get into the process to deal with the causation issue, which is how the jury apparently rendered its decision.
And you glean that from the special verdict, I'm assuming 7, 8, and 9.
Yes, Your Honor. It was clear that the jury believed that Dr. Alexander had engaged in protected conduct, but what it did not believe was that that protected conduct was the cause either of the invocation of the process or the outcome of the process, which involved, as the record reflects, graduated discipline. Your Honor, Dr. Alexander isn't arguing that there's a conflict between statutes. He hasn't pointed to any language in the two state statutes that is in conflict. His real qualm is with the fact that he was unable to make a case to successfully fit into the exception. He could have argued that this was essentially a sham process, not a real peer review process, because it was only about his behavior. But that wasn't what the record reflected. There was testimony in the record from Dr. Douglas Salvador, who established that because of the concern about inhibiting important questions from medical staff, conduct like Dr. Alexander's in terms of how other staff are treated has an impact on patient care. There was also direct evidence of the instance, or at least one instance, in which a patient witnessed this conduct from Dr. Alexander and became anxious, alarmed, concerned, and also the patient's procedure was delayed. There was ample support in the record for the jury to find that it was not retaliation, in fact, that animated invoking this process in the first place, or the results of the two disciplinary processes. Your Honors, in terms of any alleged conflict between the statutes, there is none. Not only is there no language between the two that is in contradiction, we have to look at the timing. The medical peer review privilege was established at the time that the Healthcare Whistleblower Act was enacted. We have to assume that the legislature was aware of it and had the opportunity to carve out an exception for whistleblower cases had it wished to do so. In fact, in another portion of the Whistleblower Act, the Whistleblower Act expressly refers to peer review, but fails to cut out an exception from peer review for the the healthcare whistleblower cases. We have to consider this a deliberate exclusion. The legislature had the opportunity to find a conflict between the two public policies here and said no. In fact, both of these statutes are aimed at the same thing. They're to advance the quality of medical care. And they can work harmoniously. And of course, principles of statutory construction tell us we should harmonize these statutes, and we can. Whereas sister counsel is urging us to find a conflict where none exists. And that's just contrary to the principles of statutory construction. As to a couple additional arguments made by Dr. Alexander, this discussion of the state peer review privilege having different elements than the Healthcare Quality Improvement Act, the federal act, this doesn't require extensive discussion. Essentially, Dr. Alexander is arguing that because they address the same topic, the absence of the privilege from the federal statute is significant. Your Honors, the federal statute is addressed at different issues, and in almost every instance, most states have their own privilege, so they work together. There's no conflict here. Just because one statute doesn't address something doesn't mean that the state statute cannot provide that very privilege, and here it does. Dr. Alexander also made an argument regarding the different result in federal court or against federal claims, and again, that's really a red herring, Your Honors. We're talking about different systems with different privilege rules, different rules of evidence, and that's just baked into there being different systems and different approaches to this type of evidence. The state statute is clear. In state court, this privilege applies. Finally, Your Honor, I'd like to address the cross appeal, if I may. The court, I think this was simply a plain error. The court was construing a statute that expressly applied to, I quote, an individual or an institution, including a licensed or public hospital. And it says that that individual or institution shall not be liable in a suit for damages. Respectfully, Judge Callan may have in fact been relying on a different statute, Chapter 231, Section 85N. That provides for members of professional committees to not be liable in a suit for damages. It's a broader statute talking about a variety of professions. And in this case, we have to defer to the more specific statute, which is aimed directly at medical peer review, which provides expressly for individual or institution, and even goes so far as to refer to a public hospital.
Do we have to reach that if we affirm?
No, Your Honor, I believe you only need to reach that if there is a reversal and a remand, because it would affect that. At that point, it would affect the immunity of the defendant. But without it, while we think it's plain error, I agree that Your Honor maybe does not need to reach that because if the overall verdict stands, we never get to the question of immunity. Your Honors, I would urge you to look at the long line of cases in which courts have been directly confronted with this very question, is what do we do when a litigant faces what they perceive as an unfair burden in their ability to access evidence to make out a claim because of the privilege? And again, in Pardo, in Vrenos, in Ayash, in which the court said, you can't waive this privilege. It's essentially a disqualification because the public policy here is so important. All the way back to Carr, the court has anticipated again and again that an individual litigant may suffer in their ability to obtain access about their very own proceeding, and that is in fact an acceptable cost of advancing the public policy interests that are embodied in the privilege. Your Honor, this isn't a new question. This question has been addressed again and again by the courts, and courts have said sometimes this is going to be a trade-off that exists, and we accept that in the interest and spirit of advancing medical care by allowing the profession to review itself, to scrutinize itself, and to make corrections. Thank you, Your Honors. If you have any additional questions, I'd be happy to address them.
I don't see any. Thank you very much. Thank you,
you.
counsel. The case is under advisement. Our next case is in the matter of Montana, I'm sorry if I mispronounced this, Jasiul, 25P473. I remind counsel that the case is partially impounded. Attorney Davison, when you're ready.
Thank you. Good morning, Your Honors. Juliet Davison for the appellant. The petitioner, Michael Dwyer. This appeal, Your Honor, presents the issue of whether the probate court committed legal error when she entered summary judgment on grounds that were not presented in the summary judgment motion.
Could I pause you for a moment? So certainly, and you've cited the cases that talk about the lower court's ability to grant summary judgment on other bases, and certainly the affidavits of objections reference things like mental capacity, testamentary capacity, and undue influence. But what I want to just make sure I understand your argument is true, but here we didn't know that she was going to rule in that way, and we were precluded from doing discovery that would have allowed us to test those allegations so that we can't even get to a disputed statement of material facts because you didn't give us the opportunity to even dispute them. Is that essentially what your argument is?
Yes.
Okay. And can you help me with the timeline? When was the motion to compel discovery filed relative to the motion for summary judgment? I certainly understand that the order denying it was subsequent to the decision on the summary judgment. When did that happen, and also when did that happen vis-a-vis the pretrial conference?
Well, I don't know. Well, let me tell you exact dates, Your Honor. The discovery, the affidavits of objection were filed November 2, 2023. The petitioner served discovery requests March 11, 2024. The objectors filed their motion for summary judgment and their motion for protective order on April 18, 2024. The petitioner filed his opposition to the motion for summary judgment, his opposition to the motion for protective order, and his motion to compel I think it was on April 26th of 2024. That may be off by a couple of days, but that's the time frame. The order,
And the ruling on the motion to compel came after the decision on summary judgment?
yeah, she entered, so it was a little confusing the way things were docketed here.
Well, it is Middlesex.
No comment. The order allowing summary judgment was entered on the docket on July 9th, but there was no memorandum and decision of order. And so until September 17 of 2024, so 2+ months later. And she, if memory serves, she denied the well, I don't want to misspeak, and I don't have it here, but that's the time frame. So the motion for protective order, the motion to compel was denied, and I believe it was denied at the same time that the motion for summary judgment was denied, but I don't have here whether that was on the July 9 or the
There's
September 17.
A margin order stamped on the motion that says July 12th, 2024, denied.
Yeah, but I'm not sure it was docketed then.
Understood.
Yeah. So we've, as you've said, Judge, we've laid out a number of cases supporting this position, and the summary judgment motion was a very narrow motion, and it was an entirely legally based motion, not fact-based motion, that was really based on the four corners of the conservatorship and the stipulation. So the summary judgment motion was essentially the examination was done by a psychologist, not a psychiatrist, and the stipulation said it would be a psychiatrist. Number two, there should have been strict compliance with the stipulation because Montana Jasiul was under a conservatorship. And three, that between the language of the decree and the statute, only the court had the power to make, the court would not make a will for the testator, but that power resided with the court. And the court did not address any of those legal issues. And as you can see—
And did not address undue influence, right? I mean, I read the decision to solely turn on capacity.
Correct. The judge determined, what she found was that there was a burden, that the presumption of testamentary capacity was essentially rebutted, such that the petitioner had to prove testamentary capacity due to the conservatorship, and that the petitioner had failed to demonstrate testamentary capacity. Now, if any of that had been presented in the motion for summary judgment, that would have been the opportunity to file the affidavits, which I then subsequently filed, of the petitioner, Michael Dwyer, who prepared the will, knew the decedent very well, had prepared her will in 2015.
So two questions. Was there a hearing on the motion for summary judgment? Was there oral argument at least on the—
I believe there was.
Okay. And it's possible that after a hearing, and if you had been permitted to file the affidavits and do discovery, the result could have been the same. It's just the process is the problem here.
Well, the process is the problem, and not to, in a will, the purpose of a will, the issue in a will contest is whether the testator had testamentary capacity or was subject to undue influence. And the court's entire focus should be towards determining what the evidence is that the testator either had that capacity or didn't have that capacity. This case sort of turned upside down in that inquiry was completely undermined, and I don't want to overstate the importance of the affidavits that we submitted of Michael Dwyer, the petitioner, and Genevieve Fahey, who was the second cousin of the decedent, but they overwhelmingly demonstrate that Montana Jasiul had testamentary capacity with, I mean, they're lengthy affidavits with lots of detail about daily observations and interactions. These were people who saw her a lot, made observations. The affidavits of objection were made by nieces and nephew who do not live in Massachusetts. It appears that they had been here in October of 2020, which was when she executed the will. They hadn't seen her in years. They're very thin affidavits of objection in contrast to the affidavits that we filed. And so
We have the pretrial conference transcript at record 148. Do we have the transcript of the argument? Motion for summary judgment?
So I was not counsel, and I do not, so my answer is I don't have it, and I don't know the answer.
And did the adopted daughter withdraw her objection?
She has not appeared in the appeal.
She filed the affidavit of objection.
She
But
did.
did she ever withdraw it?
She benefited more from the
She did.
latter will,
I mean, it's kind
correct?
of,
So-
Because in your
She's not
reply
pursuing.
brief, it says she does not appear to press her affidavit of objection and has failed to file a brief on appeal.
That's all
So
true.
do you think that means that her objection is no longer valid or?
Well, as Justice Tan has pointed out,
So
she
she-
fares better under the 2020 will than she did under
He
the
does, but
2015.
procedurally, I'm trying to figure out,
Yeah.
because we have 3 affidavits of objections. The daughters actually says something a little bit different than the niece and nephew, so I'm trying to figure out
Yep.
where we're at.
Yeah, I don't know, Your Honor. I think the record is what the record is.
Okay.
The counsel moved to withdraw because he said there was an objection. That was never pursued. Then subsequent counsel entered an appearance. My impression is that she has withdrawn her objection, but I don't know. Are there any other questions?
I don't see any.
Okay, I don't have anything further. Thank you.
Thank you. Attorney Jackson?
Good morning. May it please the court. Travis Jackson on behalf of the appellees Catherine Bosky and Armin Bosky. Your Honor, the purpose of a conservatorship is to protect individuals, often elderly and suffering cognitive impairments.
I completely agree with you. There is a process, if someone's under conservatorship, for someone to create potentially a new will. I'm troubled by this judge deciding a case not on an issue that was before her without giving the opportunity to the proponent of the will to at least put in other evidence, because she essentially decides, she skirts around your issue, which is what does the conservatorship allow or not allow relative to the creation of a new will. But she essentially says she had no testamentary capacity and bases it on the 3 affidavits of objection. It seems to me that if permitted, the other side would have put in some other evidence through at least Attorney Dwyer that would have created an issue of material fact. So you may end up in the exact same place that you are today, but I have a problem with the process.
Well, I understand that, Your Honor.
So help me.
The way I look at it is there were guardrails that were put in place, and there was a medical certificate that was filed in this conservatorship in February 27th of 2020. And it states that an 82-year-old woman is suffering from dementia, and there is a cognitive test that takes place. I believe it was called the Montreal Cognitive Test. At that point, the burden shifted. I think the lower court was correct in that analysis because it showed evidence of a lack of capacity.
So I agree, I'm with you.
And
How does he then show or overcome his burden if she doesn't let him do discovery to show that she did have capacity, at least as of the date that she executed the will?
the discovery really has nothing to do with the material facts of this case. You have a decedent that's under a conservatorship. You have a medical certificate that stated that she was suffering from dementia. It's assumed that the medical certificate was baked into the stipulation. The stipulation was that she would be examined by a psychiatrist to assess her ability to execute an estate plan. That speaks as to there's guardrails in place to determine whether she had testamentary capacity.
All right, but let me ask you this.
None of this.
At page 5 of her decision, I think it's a finding of fact, the judge says at paragraph 24, we have no information concerning the decedent's mental status on the date of the will execution or who was present at the will execution other than the 2 witnesses to the will and the notary and presumably Attorney Dwyer. She would have had that information had she permitted discovery and responses from Attorney Dwyer. So again, we may end up exactly where we are today, but there's a process problem here.
So the record has the transcripts from the motion for summary judgment hearing. And
Can you tell me where that is in the appendix? I apologize.
so it's styled, Your Honor, as the pretrial conference,
That
but
is the
that's
argument
when
on
the
summary
argument
judgment?
takes place.
Thank you.
And I would, I think it's very important for the purposes of this appeal. For argument's sake, I will reference the fact that the discovery that they go back and forth in the hearing, and you'll note they go back and forth about whether discovery is necessary or not, and that was the purpose of the protective order filed by former counsel. I agree with the judge that for the purposes of her findings, discovery wasn't necessary. There's 5 material facts that she based her finding on that are undisputed by pleading or during oral argument.
And what are those?
Under conservatorship, medical certificate that I've already referenced, a stipulation that was negotiated between 2 attorneys, elder services, and private counsel representing the decedent, that specifically outlines her the need for a psychiatrist and her ability to execute the estate plan. It's undisputed that she was examined by a psychologist, not a psychiatrist, but it doesn't appear that there was a lot of weight put into that for the purposes of the decision. I think the most important thing for the court to keep in mind is 5 months. 5 months passed between the evaluation with the psychologist and the changing of the estate plan. My argument is, and prior counsel's argument was, that the train stops there. That's the end of the analysis because there was already protections and guardrails in place to ensure that she had testamentary capacity at the time of signing. It's undisputed that 5 months passed and there was no evaluation, whether it be from a psychologist or a psychiatrist.
Didn't the stipulation also allow the decedent to manage some of her finances, including her real estate, both here and in California?
It did.
And so isn't there an issue of disputed fact? We have a medical certificate that says she has dementia. We have a stipulation that says she's going to be reevaluated, but also says she can manage property in 2 states at, I'm going to call her a seasoned age, in her 80s. That, to me, suggests that there is an issue of material fact that would warrant an evidentiary hearing with witnesses.
Perhaps. The way I look at it is they're not the same. There's a stipulation in there that states for the purposes of doing an estate plan, she needs to file, she needs to be evaluated by a psychiatrist, and that was circumvented. And 5 months passed, I'm not an expert by any means, but 5 months passing with somebody with moderate dementia.
Do we have a case that talks about the timeline? To me, 5 months isn't a magic number. Do we have, could it be 2 months? Could it be 9 months? Is it dependent on the person?
I don't have one off the
We do
top
have
of my head.
cases that say that you can be competent 1 minute and not competent the next.
The
This
spirit.
all goes to the question of, is there an issue of material fact?
My argument is there isn't. As you alluded to, Your Honor, it's very possible that we end up in the same spot that we are down the road. If
Do you
this
think the judge looked at the record in the light most favorable to the proponent? And if so, where does she say that in her decision? Because I didn't see it.
So when I read the decision over and over again over the last couple of days, and I was asking myself the same thing. I think my argument for that is in the light most favorable. My interpretation of the finding is she basically gave a pass on the fact that it was a psychologist, not a psychiatrist. And she gave a pass on the fact that no cognitive test was done, even though that clearly was the spirit and intent of the stipulation. However, the burden that shifted, the stipulation was not followed. 5 months passed with somebody with moderate dementia that wasn't properly evaluated. So I do think in the light most favorable to the non-moving party that the judge considered the facts that she needed to consider. Unless you have any other questions.
I don't see any. Thank you very much, counsel. The case is under advisement. Our next case is Augustin M. Florian, M.D. versus Boris BERGUS, M.D. I'm sorry if I've mispronounced that. And another, docket number 25P371. Good morning.
Good morning, Your Honor. May it please the court. I represent the appellant, Dr. Boris BERGUS. Dr. Florian did not have standing to bring this case in the first place. At the time of contracting, he insisted that his professional corporation, not him individually, be a party to the contract.
So you say, is this a pleading error? If they had named the corporation of the plaintiff, you wouldn't be making this argument?
That's correct, and they, and this case was pending in the Superior Court for nine years, and they had every opportunity to amend their complaint.
We looked to the agreement, right, to see what the intentions of the parties were?
Correct.
And the agreement was for Dr. Florian's professional services, not the corporation?
Yes, at bottom, it is his professional services, but you can enter into an independent contractor agreement to provide professional services, and the party to the agreement is the corporation, not the individual.
But if the whole contract was about compensation for his professional services, why isn't he an intended beneficiary of the contract?
Well, he's certainly a beneficiary because when his corporation obtains revenues, he ultimately is a beneficiary of that, but he's an incidental beneficiary. To be an intended beneficiary, you have to meet very specific requirements. Certain boxes have to be checked. The SJC has adopted Section 302 of the restatement, and Section 302 allows a non-party to be an intended beneficiary only if it's necessary to effectuate the intent of the parties, number one. And in this case, we have perfect insight into the intent of the parties. In 2015, when they entered into this agreement, Dr. Florian, after consulting with his attorney, struck his name from the draft and put in the name of his corporation.
For tax purposes.
For
Every
tax
doctor
purposes,
does it, I would
exactly.
guess.
And when you do it for your own purposes, in this case, they concede that this was done for tax purposes, you should be held to your choices.
But there's no question here, right, that this is all, that the doctor was the intended beneficiary. I mean, some of the payments were made directly to him personally, right?
Mistakenly, I mean, which you can understand. It's Dr. Florian, MD, comma, PC, and sometimes the PC wasn't put in there. That's true.
Maybe your argument time would be better spent on something else.
But there are equitable considerations. He took advantage of tax benefits. If the shoe were on the other foot, if we were suing Dr. Florian under the agreement, and there are certain...
You're still talking about standing, right?
Yes, certain obligations going both
I think
ways.
you should move on.
Sure. The other primary argument we make is with respect to damages. This case makes a mockery of the requirement that damages must be proven with reasonable certainty. Dr. Florian's counsel cannot point to any testimony from Dr. Florian or any other evidence for that matter that provides anything close to a reasonable explanation for how he calculates his damages. He literally took the stand, Dr. Florian, and said, I think I produced about $1 million, and every year I did the same or even better. Not much more than that.
And his son?
His son.
And his son, who just by happenstance happened to review some records several years ago, which he doesn't.
He offered testimony on how many patients he saw per day, what he made in certain years, and how it graduated at a level of 25% a year.
Just based on nothing.
And
based on
BERGUS didn't put any evidence in that contradicted any of that.
They put, Dr. BERGUS put in evidence of billing records, which the plaintiff contends were incomplete, but without providing any proof, any evidence.
So this was one of those nifty Rule 20 trials in the Superior Court.
Correct.
So it has to be upheld, if anywhere in the evidence, from whatever source or any combination of circumstances, one could draw an inference in favor of the prevailing party. That's a pretty low standard.
That's a pretty low standard, and this case is a pretty low quantum of evidence.
But there is evidence of damages. It's not evidence that is certainly mathematically a certainty, but there is evidence from whatever source that they could draw an inference.
So Dr. Florian, in a very vague and unspecific way, said that he saw a range of patients per day, from some number to some number. Had he put on evidence of what each patient visit resulted in terms of billing and revenue, and then you have to take a further step and get to net cash receipts, which is what his commission was based on in the agreement. Net cash receipts.
Was he ever paid any of the 30% of the net cash receipts ever?
It's very difficult to say. We know from.
Let me put it another way. Is there evidence that he was paid any of these net cash receipts at 30%?
It's impossible to say because,
No, evidence.
well, no, there
There's
wasn't
There's no evidence in the record that he ever received any. Well, let me ask you this: was there any? Was there net cash receipts vis-a-vis Dr. Florian?
Yes, certainly.
And he was never paid the 30% of that.
Because the $1,000 minimum daily payment, which he did receive and which he admitted receiving, you only get more than that if the 30% exceeds $1,000 a day.
There was evidence that some years he brought in as much as $800,000 to $1 million.
And he plucked that out of the air. Literally no evidence.
You didn't put anything in to counter it. Rule 20 is a tough vehicle to drive on appeal.
Yeah, and this case is such that the evidence is so paltry, and I believe plaintiff's counsel will have a difficult time pointing you to anything specific in the record, in the testimony, other than just throwing out numbers, getting up on the stand and saying it's probably about $1 million.
I'm sorry to interrupt, but you make an argument that Michael's testimony violated the best evidence rule.
That's right.
Was there an objection on best evidence grounds at trial?
My review of the record I didn't see those specific words used. You're an experienced litigator. You understand that's a problem. Well, the plaintiff has not raised that as a problem. They don't consider that objection to have been waived. They do argue waiver in a different part on a different issue, but not on that.
We don't need the appellees to explain to us what appellate review is.
If they're going to press a waiver argument, I think they need to actually make that argument.
Let me put it another way. They don't waive a waiver argument if it's not apparent on the record that this was preserved for appeal.
Like I said, there are objections in the record. I don't think anyone used the words best evidence.
You don't cite to any of them in your brief.
No, and the plaintiff doesn't.
And that is a problem for an appellant.
And the plaintiff doesn't even allege in their brief that that wasn't preserved. I might be able to point to something, but as I said, whether it's specific.
16A9, Mr. Dawes, requires you to cite to the record.
Well, we believe that the testimony is lacking in several respects. That's just one of them, Your Honor.
The other thing, you say that the judge erred in relaxing Florian's burden of proof.
That's right.
So there was some discussion about the standard differing on the Wage Act claim on which Dr. BERGUS prevailed, right?
That's correct, yeah.
But where is the evidence in a Rule 20 trial that the judge relied on an improper standard? Where do we get that from?
Well, the plaintiffs made the argument to the judge. Yes,
they made it vis-a-vis the Wage Act claim.
I don't believe it was limited to the Wage Act claim.
Well, again, you say these things in your brief, but you do not cite to the record. Where is the record support that the judge relaxed the standard?
Well, the judge didn't, because it was a Rule 20, the judge didn't write a...
Right, and that's why you can't make this type of argument on appeal.
Well, I would say that...
My understanding is she asked that question about the Wage Act only, not the breach of contract. Do you disagree with that?
That the judge
About the
cited...
burden of proof.
I'm sorry, that the judge cited Anderson just as to...
The judge asked about the relaxed burden of proof as it related to the Wage Act claims only, not the breach of contract claim. And if that's what she said, I think you're asking us to extrapolate from what she said in the Wage Act to the breach of contract, and I don't know how we do that.
Well, I'm having a tough time because of the Rule 20 nature of this. But I suppose our position is, Your Honors, is that the evidence was so paltry that it doesn't rise to the level of being reasonable, having reasonable certainty to it, unless what the judge did was shift the burden. So,
Anywhere in the evidence, from whatever source, that anyone could draw an inference in favor of the verdict.
that's correct. That's what we're stuck
So,
with.
so
And
labels of paltry can't combat the Rule 20 monster that was created.
well, Rule 20 or not, even a jury trial, you need to put in some evidence to meet that reasonable certainty test for damages. And I would proffer that in this case that wasn't met.
Do you have a citation to a Rule 20 case on certainty of damages?
We don't, not a Rule 20.
I couldn't find one.
But a Rule 20 case is supposed to be viewed as a jury trial case. And there are cases where a jury has ruled in favor of the plaintiff, and that's...
The problem is that juries don't decide how to apply legal instructions vis-a-vis the burden of proof being relaxed or not relaxed. They get the instructions from the judge. And if the judge misinstructs them and relaxes the standard, that's reviewable. We have judge and fact finder wearing the same hat in the Rule 20 circus.
The argument, I mean, it's really an alternative argument that if you find that the evidence on damages does not rise to a very minimal level that it needs to rise to, then the plaintiffs may fall back on this idea that, well, maybe the burden really wasn't on us, maybe it was really on the defendants, and so we're arguing that that's inapplicable in this case. But you don't even need to get there if you buy my argument that the evidence just isn't there. And again, I would be interested to hear what plaintiff points to in terms of evidence to support their calculation of damages. Unless there are any other questions, I'll rest on the brief.
I don't see any. Thank you very much.
Thank you, Your Honor.
Attorney Flam?
Yes, Your Honor. Good morning. May it please the court. At its core, this is a case about honoring the bargain that the parties actually struck.
Why not just amend the complaint?
Well, Your Honor, we were not counsel. There were several.
Well, I'm
versions
shooting the
of counsel.
messenger, but you'd agree with me. Rule 15 would have allowed you to amend the complaint.
It could have, Your Honor. We were, when I came on, it was post-discovery, so it's not quite as simple. But at the time I came on, there was a pending counterclaim, and in no less than at least 8 paragraphs, they assert that Dr. Florian was a party to the contract. We know that because they sued him under that contract. And you can't sue someone under a contract that they have no rights under. Right? They sued him for indemnification under the contract. They sued him for returning monies that he had been allegedly overpaid. And they only dropped their counterclaim, judges, at the charge conference on the eve of the last day of trial, when they were confronted with the fact that, again, you can't sue Dr. Florian under a contract which you claim he has no rights under. So would it have been cleaner if the PC was named at the beginning of the case or later? Absolutely, Judge, yes. But here, the question before the court I would submit is whether or not there was enough evidence under the Rabasa standard that Judge Meade, you pointed out, anywhere in the record to show us that Dr. Florian was either an intended beneficiary of the contract or that he was indeed a party to the contract. And there's sufficient evidence for both under the Rule 20 standard. If we take a look, judges, at the intent of the parties, right, it's very clear that the intent of the parties was to secure the surgical services of Dr. Florian, right? He was a former chief of cardiothoracic surgery who was being brought in at the end of his career to do some plastic procedures, some varicose vein procedures, sort of ease into retirement. And he was a known name in this industry. This all came out at trial. So they brought him in and said, we'll give you $1,000 a day and 30% of what you bring in. And he says, after having worked at a hospital for many years, can we do this under my PC for, as the bench pointed out, a tax purpose? But nothing else in the contract changed. That contract that was designed to secure Dr. Florian's personal services remained the same. And he didn't even get that benefit because, as we see, they wrote the checks to Dr. Florian directly. So the checks didn't even go to the PC. He didn't even get the benefit of that change, which is why, if we take a look at the way they treated him during the contract, paying him directly, taking the services from him, and we look at the way they treated him after the contract by suing him as an individual and not impleting the PC or any other thing they could have done, we see that it's very consistent that he was always considered to be an intended beneficiary, and the record supports that under the Rule 20 standard. Alternately, it's possible that Judge Cloutier could have essentially blue-penciled the agreement, because if the only thing on there was the name, and we don't look at just the labels, and you change the name to Florian MD, everything else remains exactly the same. Nothing changes. And under the Rule 20 standard, there's enough evidence in the record for that to have been the finding. Because when we look at the verdict slip,
Because she can amend the evidence, she can amend the complaint to conform with the evidence, right?
absolutely.
Can she do that sua sponte without a motion from you?
I believe she can, Your Honor, because the question on the verdict slip was whether or not there was a contract that was breached, which was enforceable by the plaintiff.
And she said yes.
And she said
answered
yes.
that yes. Okay.
If there's no further questions on the intended beneficiary, I'll shift to the damages question, okay? There's a plethora of evidence, not the best evidence.
Did Florian keep his own records of patients that he saw, or what he billed, or days that he worked?
No, Your Honor. To reframe the discussion a bit from the way my brother presented it, this is the 21st century, right? We have electronic records. Which patient came into which office on which day, saw which doctor, had what procedure done, how much they paid, how much they still owe. These are records that you have to keep for business purposes and practically speaking, for legal and ethical purposes as well. Dr. BERGUS testified on cross that he had, quote, pristine records, yet refused to submit them to the court. And we learned why. Michael Florian was the office manager. And my brother mentioned the issues a little bit with the billing companies. They switched from time to time to time, 6 in total in 4 years, because they were trying to negotiate better prices, Your Honors. So we know that as of in May 2013, Michael Florian started getting access to the company's books, to the records, because he needed to have that information in order to shop around for the insurance billing providers. And the chief operating officer, Mrs. BERGUS, confirmed just that during her cross. So we know that when Michael Florian says it was between $800,000 to $890,000, it was based on his own personal observations. And under the Cody decision we cite in our papers from this court, that trial testimony is entitled to be credited by the judge.
Was there a best evidence record objection?
There was not, Your Honor. First of all, and second of all, if we're taking a look for a moment at what appellant's position is, it's the following. We are not going to submit the evidence that we testify we have under oath. We have these records, and we're not going to submit them to the court. And then we're going to complain that the evidence isn't here. It doesn't make sense. And we know why. Because Michael Florian testified that Dr. BERGUS was changing the providers around because some were only credentialed to do certain things. We know that at one point there was a $500,000 discrepancy. We learned that from the company's own bookkeeper. And we also know, as is demonstrated from Supplemental Appendix 3, it's 120 pages of medical records. Those were critical at trial, Your Honors. Those were actually, believe it or not, still in the email system of Michael Florian. That's how they came out. And what they show is, as admitted by Dr. BERGUS on cross, you see all the records not all the records, but all these records, Dr. Florian performing procedures. He is the, quote, MD, which is the doctor. No dispute from Dr. BERGUS that Florian performed those procedures. But the top page on the file says BERGUS. BERGUS was taking credit for Florian's work. So even if they had shown some records, their records were not reliable. So here, under Cody and the rest of the cases that we've briefed, the Superior Court had to do the best with what it had. And we have the
Are those documents you just referred to, is that where the insurance anomaly was uncovered?
That's part of it, Your Honor, yes. That's part of it. There were two pieces of the insurance anomaly. Number one was that BERGUS was taking credit for Florian's work, so we had to look at Michael Florian and Dr. Florian's testimony because we couldn't get it from records, because the records were cooked, frankly. Secondly, they had 6 billing providers and gave partial information for 3. And when you looked at the actual information, Mr. Herzl, the paralegal employed by defendant's counsel, admitted this on cross. When you looked at the actual billing records from the third parties, they came with a proviso. Double check these, make sure they're accurate. Mr. Herzl testified no one did that. Mr. Herzl further admitted that he never cross-checked those billing records with Encompass's records, the same ones that BERGUS testified were pristine. So, frankly, we don't know what those records are. There is no quote-unquote best evidence.
BERGUS says that the per diems paid exceeded what he'd recover under the 30% net proceeds.
He did testify to that, Your Honor. 2 things. Number one, again, under Cody and its progeny, Judge Cloutier was entitled to disregard and disbelieve that testimony because we have evidence. I'll turn you again, Your Honor, to Volume 3, Record Appendix, Volume 3. We see that BERGUS was taking credit for Florian's work. And that is how the Superior Court could very well, under Rule 20, have concluded, under Rabasa, that he certainly did Florian did go above and beyond his daily minimum. And that's where the testimony from Michael Florian, the office manager, who reviewed how much each doctor was bringing in and when, became relevant.
Florian's numbers alone show that they exceed the per diem, right?
Absolutely, Your Honor, yes. Because if you take 30% of 800 to 890 plus $1 million, plus 1.2, because it grows 20% every year conservatively, that's already $3 million, Your Honor. You subtract, the 400-something thousand, I don't have the specific number, 420,000 that he made, and you're supposed to get that delta, right? You take 30% of $3 million, that's $1 million.
The judgment was for 658.
657, Your Honor, yes.
How much were you asking for?
658, Judge. And that's further evidence. Look, the court did not rubber stamp our request. We had to, as I was just explaining, Your Honor, you have to take a look at all the paychecks, right, for the $1,000 a day, and you have to subtract that out of the 30%. And given that we were within, based on the testimonial evidence, about $1,000 of what Judge Cloutier found, it's evidence under Rule 20 and Rabasa that this was indeed a careful analysis. If it's okay with Your Honors, I see my time is short. I'd like to turn, unless you have more questions, of course.
Prejudgment interest?
That's where I'm going, Judge. Yes, sir. So here's what we know. We know that every single day Dr. Florian worked, he did a procedure, and money came in. He never got paid. Each of those paychecks is an independent breach. And under Section 6C we all agree that's the right statute, you get prejudgment interest from the date of the breach or demand. So it appears that what the Superior Court did, Your Honors, is look at the last day that Dr. Florian worked. And here's what we know from the record. If we go to Record Appendix 1 at page 92, judges, the last paycheck was October 7th, 2015. So it appears from the record that the Superior Court went 1 week forward, and at that point in time, on October 13th, 2015, every single breach had already occurred by necessity because he never worked again after October 13th.
Was that 1 week forward, was that the email?
The email, Your Honor, was 10 days later, on October 23rd.
Okay.
But what we know is that October 13th is approximately 1 week after his last day worked, and at that point in time, every breach has already by necessity occurred, which means that this was a conservative estimate that was actually in the favor of the defendants, because there were breaches going as far back as August 2011, which would have garnered much larger prejudgment interest awards. So I would argue that this is supported by the record, and of course, from the Halatki, forgive me if I'm mispronouncing that, the SJC case we cited in our brief from 2020, HLATKY, we know that the date of the breach is a question of fact. And in this bench trial, there's ample evidence in the record to support the conclusion of October 13th, 2015. Finally, with my last minute, I'll just turn to the issue my brother raised about the shifting of a burden. If you go, Your Honors, to Record Appendix 1, pages 165 and 166, you'll see that in the plaintiff's post-trial briefing that the question of relaxing a standard for evidentiary burden on damages was indeed under the Wage Act, and it's not until the next page, RA 166, that the contract section even starts. So it's pretty clear from the record that Your Honors had it right. That's exactly what happened. Again, because the defendants hid the records from the court, because the defendants were not credible, the evidence is more than sufficient for the judge to have determined privity of contract, intended beneficiary. The damages are well supported in the record, especially under Rabasa and the Rule 20 standard. The prejudgment interest is grounded in the record, it's grounded in the breaches. It's a well-reasoned decision based in large measure on credibility, and we ask the court to uphold it. Thank you.
Thank you. The case is under advisement. Thank you all. The court will stand in a brief morning recess.
All rise, please.
Nice work. Nice job.
What is the recess?
How's this?
We will resume our list with John Doe number 523373 versus the Sex Offender Registry Board. I remind counsel that this case is impounded, so you must use pseudonyms. Mr. Gauthier, when you're ready.
Good morning, Your Honors. May it please the Court, Edward Gauthier representing John Doe. During the break, I had a good conversation with opposing counsel because this case highlights some of the challenges attorneys who represent clients before the board have. And the first is we do our best to get a decision from this court within 36 months of the hearing because our clients are entitled to a new hearing every 36 months. So after that point, the case essentially becomes arguably moot. In this case, the case was delayed in the Superior Court for 2 years. So my client is entitled to a new hearing as of December of 2024. The second challenge is getting funds for experts. In this case, Doe moved before the hearing examiner for funds because Doe was diagnosed as having antisocial personality disorder in 2020 while he was at the MTC. He wanted an expert to come in to testify possibly that no, Doe does not actually have that. I will concede that the best practice when doing motions for funds before the board is to identify the expert specifically, include a curriculum vitae, and perhaps a short write-up by the expert as to what the testimony might be. And I would concede that that's not here, and I will say that I have had trouble in the past doing that myself because many experts aren't willing to put in the legwork before.
But are you conceding the issue before us? Or?
I am not conceding the issue. I'm simply saying that there is a better or a best practice. However, in this case, the individual the motion that was filed does identify the specific disorder that Doe was diagnosed with, identifies what the individual potentially would testify to, and the antisocial personality goes to antisocial traits. The two primary factors that drive recidivism are sexual deviancy and antisocial traits. So having antisocial personality disorder essentially checks one of the two boxes that goes to sexual recidivism, and the hearing examiner in page 28 of the decision specifically cites antisocial personality as part of the decision-making process.
But didn't the examiner just note it, I guess, the antisocial behavior disorder in, I believe it was in discussing factor 35, right?
Correct.
And there really isn't much or any other reference to it that didn't seem like there was weight given to that, to your client's.
In the discussion section at the end of the decision is the discussion of the factors on how dangerousness and risk of reoffense were found, and it was not mentioned there. I would concede it is only mentioned in the discussion of the psychological profiles, risk to reoffend, but it was noted by the hearing examiner, so it was something that perhaps went into the thought process. We don't know, though. The other issue that we have representing clients in these cases is how to go about challenging board factors. If we challenge it on a scientific basis, of course, we go a different route with a declaratory judgment. In this case, before the Superior Court, Doe argued that the board hearing examiner misapplied 4 regulatory factors. And I've read all the SJC cases and this court's cases, and I'm hard-pressed to find many instances in which a court at any level really takes umbrage with how a hearing examiner applies factors. In this case,
I'm actually interested, though, in the argument about the property crimes.
So violence unrelated to sexual assaults, factor 11, specifically says they apply to crimes against people and animals, not property crimes. So in this case, the hearing examiner applied the factor 11 because Doe has a number of property crimes, burglaries, malicious destruction of property.
Is there such a thing as a violent property crime?
According to the regulation, it would appear no, and I think the board would concede the answer is no, but the board's argument is that even if you excise property crimes, there was sufficient evidence in the record of an old assault and battery.
So let's talk about a burglary or breaking and entering. So it starts out as a property crime, but if someone's home, that to me becomes a violent property crime and potentially an assaultive crime.
It could be. In this case, there are no police reports, so the hearing examiner,
No.
so we don't know. So we don't know the underlying facts of any of Doe's crimes other than his index sex offense. So we don't know if anybody was home. We don't know the nature of any of his crimes. We just know that he either has a conviction, a quaff, or the cases were dismissed. So I think the board would concede that the property crime shouldn't have been considered, but Doe does have a single assault and battery from 1999 when he was 15, when, according to him, he was had to remove his landlord from his house. So that's essentially the basis of that. The other disagreement Doe has with some of the factors, including factor 13, was he believed that the board hearing examiner essentially didn't listen to the language of the regulation. So for factor 13,
Language of what?
the language of the regulation. So for noncompliance with community supervision, factor 13, the board regulation directs the hearing examiner to weigh the number of probation violations, the seriousness, and the amount of time that's elapsed. Well, there are 3 violations of probation on his Board of Probation record from 1997, 2009, and 2011, and the board hearing examiner doesn't really wrestle with the information in the way that the factor requires. He simply says, there's 3 violations, I apply this factor. There's no evaluation of the seriousness because we don't know anything about these violations. They could have been for non-payment of probation supervision fees, for all we know. In terms of, and there was no evidence was introduced at the hearing regarding the seriousness of the violations, what they were for, and they are pretty old. 2011 was his last violation of probation. In the same vein, he takes umbrage with how the hearing examiner applied supervision by probation or parole. Doe has been on probation in the past. He completed strict monitoring pretrial, in this case for 2 years and 4 months leading up to his incarceration. He also completed probations in 2009 and 2012, but he doesn't get full credit for being on 3 years of strict supervision because of these 3 unknown violations from 15 years ago or later, which again could simply be for non-payment of fines. Other than that,
Well, he had 12 D reports?
he had 12 D reports while he was incarcerated.
And some are de minimis, but some involve contraband, possessing materials to make alcohol in prison, and resulting in him having, is this true? I'm not going to ask you if it's true. This is what is in the record, 20 gallons of a home brew in his jail cell.
It seems like a lot, I would agree. He did have difficulty behaving himself in prison because of his substance abuse issues. And 20 gallons, I don't know what that would look like, but I don't know how that would be hidden. That's a lot. That is a lot. He does, under the factor for substance abuse, I think, was applied with full weight. It's clear that his time in the community, he admits, while he was at MTC, that essentially his criminality is almost entirely linked to his substance abuse issues, and that factor was correctly applied. So I would agree that his behavior while he was incarcerated was not ideal. However, the last 2 years he was incarcerated at MTC, he was a very good prisoner, and he did sex offender treatment programming while he was there, for which he was given some
So what
credit.
do you think he should be a level 1?
I don't have an opinion, Your Honor.
What did trial counsel think?
I'm not an
What
expert.
did they argue for below?
We always argue for relief. Or level 1 at the most.
At the most.
We argue that in every case. We don't have the expertise of the board hearing examiner, so we don't carry an opinion what our client's level should be. But as attorneys, we always argue for relief. We file a motion for relief from registration in every case, and we argue for a level 1 at most. So, of course, we would be arguing that he should be relieved of his obligation, or that he should be a level 1 at most. If there are no further questions from the panel, Doe would rest on his brief.
Thank you very much, Mr. Gauthier. Mr. Haynes?
Good morning, Your Honors. James Haynes on behalf of the board. I will try to also be succinct. Doe was convicted of rape after an unsuccessful encounter with a prostitute culminated in him knocking her unconscious with a brick and leaving her in a parking lot. So the examiner classifying him as a high-risk level 3 offender was based upon substantial evidence, both about this incident as well as about his history and circumstances, which provided an independent basis for concern. And it was neither an abuse of discretion nor error to apply the factors or at the weight that they were applied, or to give him that classification. She also didn't abuse her discretion in denying funds where Doe's motion was procedurally deficient, and where ultimately she didn't place very much weight.
So the property crimes,
Sure.
I don't love that that's in there, but I also see that you say, even if you excise that, the decision still stands.
I don't love that they were in there either. It's actually the only time I've ever seen them in one of our, in
So that might be
Factor 11.
something to take back, right?
That might be. So I do think actually the point that you brought up during my brother's argument does have some weight to it. I wasn't really going to nail my colors to that mast, but I do think that there is a difference between, for example, a larceny where I, steal your water pitcher versus if I take it out and throw it through the windshield of your car. That's malicious destruction of property.
There needs to be a little bit more finesse around. I think there
Yes.
can be violent property crimes, but this lacked the finesse that I would like to have seen.
Yes, I would concede that I don't think that they were probably appropriately considered in there, but again, I think the factor overall was appropriately applied because you do have other evidence within the record of Doe having a history of non-sexual violence. You do have I believe he's got a DYS commitment going back to his juvenile. He's got the other thing that springs to mind is I believe he had effectively sort of a domestic, and which gave rise to a 209A order, a non-abuse. And there was evidence in the record, I believe both from that case itself as well as it being discussed in some of his treatment records where, he contested, he said, well, I only ever yelled at her, I never hit her, but she had said, no, this actually did turn into a physical assault. And it's, again, that's the sort of fact-finding that the hearing examiners are allowed to do. And also it's notable that the treatment center, when they were scoring him on the actuarials, the Static 99 does have an item for non-sexual violence. They did score him for non-sexual violence, and they did score him based on that domestic incident. So you have more than one voice saying that there was a factual basis for the application of that. So on the whole, I would have preferred property crimes not be considered under Factor 11, but I do think that Factor 11 was not mistakenly applied here. In terms of the other two factors, well, there's three other factors that are challenged. There's Factor 12, that's the disciplinary while incarcerated, and I do think he did have 2 good years at the end of things, but he had 5 bad years that preceded him. And yes, I would say when you're trying to weigh one against the other, when you put 20 gallons of Pruno on the scale, it does go towards applying that factor correctly. And in terms of Factor 13 and 28, those kind of dovetail together. They're both about probation. He does have probation violations on his record. I don't recall if there is a great deal of information within the record as to what they were about, but I don't know that there was anything showing that they were absolutely, failure to pay victim witness fees or something like that. So he does have violations in there, and that is a basis both for applying Factor 13 as well as for discounting mitigation under Factor 28. And again, he does have some successes on probation, but one of the ones that my brother brought up was the successful completion in 2012. Mr. Doe completed that 3 days before he committed this violent rape, and also there is evidence in the record that during that time he was under court supervision. He was routinely abusing drugs, drinking to excess, and frequenting prostitutes. So it's a success, but it's one that I think has something of an asterisk by it. In terms of the motion for funds, I think there You can get into the question of antisocial personality disorder, but I don't think that ultimately it's sort of a blind alley in a way. I think that the question is whether or not it was an abuse of discretion to deny this motion, and Doe's motion for funds was on its face deficient, and it's generally not an abuse of discretion to deny a motion when it doesn't meet the requirements that it's expected to meet. Particularly here, I think the most important failure is the lack of nexus. It identifies ASPD, kind of, but all it does is says, well, there's this diagnosis of ASPD, so it must be relevant, and it does not connect the dots as to how. I know that it is probably difficult to get an expert to write up an entire report on spec, but I think you could, as an attorney, say, well, make the argument that my brother just made here a moment ago and say there's antisocial personality, some sort of, maybe it's a diagnosis, maybe it's not, but you use words like that in your factors, so it is probably relevant to things. Why don't you give me some money so that I can have somebody explore that further? That wasn't what happened here. He just said it's relevant and moved on. So I think that is a problem. And he did this, I believe the motion was filed in April or May of 21, and then Mr. Doe, because he had 2 hearings, had a second hearing in December of 21, and I don't believe that there was any effort during that entire period to, correct the mistake, move for reconsideration, try to expand on it. So, I would say it's doubly not an abuse of discretion where the problem was identified and really nothing was done to try to correct it.
Isn't it hard to make out the sufficient, I feel like it's a little bit difficult to make out. I understand what you're saying, and it's abuse of discretion, but do you know, like if you're seeking an expert, right, and you're saying, well, my client has this disorder, but you need to be able to consult with the expert to sort of be able to make the showing to say this is the nexus. Do you know what I mean?
Respectfully, I disagree. I think it is possible so I think one thing that counsel below did right here was that he did consult the DSM and included the section on ASPD within his thing, but I think he could have taken the material that's in that and made the argument. He could have said this is a person who has this personality disorder. Some of the hallmarks of this personality disorder, according to the DSM, are, glibness, lack of empathy, tendency to do things without giving very much thought to the consequences. All of those things are problems, and they may have some bearing on his risk if he actually has this condition, and therefore, we do need somebody. He didn't do that. He just basically said it's relevant and moved on. So I think it is possible, even as laymen, to at least look at a general explanation of what a condition is and tease out, say, here's why I think this could be relevant, and an expert could probably give you a much better explanation as to why. Had he done that, maybe he would have had a better shot here, but he didn't make that effort, and I think it's not an abuse of discretion to deny it where even that sort of effort hasn't been mooted. The other thing about that, though, again, is that, as I believe you noted, the ASPD doesn't really carry much weight in this decision. It's noted in a bullet-pointed list of 4 diagnoses that he had. It's not discussed in the discussion at all, and it's not looped into any of the factors that were applied where the term antisociality is also applied. You don't see, for example, I think Factor 8 has antisociality language in there, and you don't see the hearing examiner saying, well, I'm applying this, but I'm applying it with extra weight because hitting a person with a brick is the sort of thing that you would expect from a person who would have this lack of empathy. She's not tying in the diagnosis to the application of the factor. And I think that is another reason for finding that it wasn't an abuse of discretion, because she just simply wasn't relying on it very much. I think to distinguish it, 89230 is the SJC case. And there you have an example of a person specifically saying, I have bipolar, giving an example of why it would have been relevant. And then also, after his motion for funds is denied, the hearing examiner turns around and uses the bipolar against him to his detriment. And that didn't happen here. Again, it didn't happen with the ASPD diagnosis, and I would say it also didn't happen with the actuarial test results, which was the other thing he was seeking expert testimony for. She notes them. She says if they're done correctly, we'll use them as sort of general information that applies or that's helpful, but we're not adopting their recommendation. It's not dispositive. Unless the panel has any questions, I'm prepared to rest on my brief.
I don't see any additional questions. Thank you very much, gentlemen. The case is under advisement.
Thank you.
Our next case is the Department of Children and Families and Others versus Mother and Others, docket 25P850. I remind the parties the case is impounded, so please do not use any names. And I understand the appellees will be splitting their time 7.5, 7.5. Yes, Your Honor. Excellent. Good morning, counsel.
Good morning, Your Honors. Laura Krismer for the mother. There are three issues in this case, but what I wanted to do is to start with the issue of the limited exception that was carved out in General Laws, Chapter 119, for foster parents to attend and be heard. I wanted to just start by saying I think it would be extremely helpful both for juvenile court judges and litigants for this court to issue a published decision on the issue, because there's a big gap, for lack of a better word. I wanted to start on that issue is that, as the court is aware, 119 sections 65 and 38 both create this closed proceedings for care and protection proceedings.
So I have a lot of questions, so I'm just going to interrupt you
Okay.
so that we can get through them.
Sure.
I understand the argument. I think it's a very interesting issue. My first question is, would your argument be different if there had not been a motion to sequester?
If there had not been a motion to sequester and nobody made a big deal about I think it would be different.
Okay,
I think
so
it would be
then
different.
Let's assume motion to sequester is filed.
Yep.
Judge sequesters foster mother until she testifies.
Correct.
And then allows her in for the rest of the proceedings. How does that change your argument?
I think the allowing, unless there was a clear indication that the foster parent was not going to be recalled, like my experience as a trial attorney is normally the judge will ask the attorney who called the witness, do you plan to recall or does anybody plan to recall the witness? If they are not, then I think that there is some argument that if they're with a sequestration order, that they might be allowed back in. However, that's not even getting into 29D. That's only addressing sequestration, because 29D is a limited exception. And I would suggest to the court that, as DCF points to a case, care and protection of Charlene, with regard to the public policy, and that is not just to protect the children. It is to protect the parents who have an allegation of unfitness and to the remediation. In this case, there was a lot of very personal information, sexual information, mental health information, that the foster parent really didn't need to know and certainly wouldn't normally have access to.
Why does the legislature give the foster parent the right to attend?
So that arose, in terms of doing, one of your lovely law clerks, I think, could probably do this, having been a law clerk myself once. It arose because what was happening was the courts were using 65 and 38 to preclude foster parents from attending. And judges were saying, hey, wait a minute, we want to get the information from these people who are caring for the child to find out, like, what's going on, basically. And so 11929D was carved out as a limited exception. And so the goal of the attendant be heard was for the foster parent or the guardian to be able to come, speak, even if somebody didn't call them as a witness, because previously, if you were called as a witness, then we would go through the sequestration that Your Honor we just went through. But this allowed them, if nobody ever called them, they could show up and they would say, I would like to say something about this case.
So
Do you have a question?
Are you asking us to interpret 11929D to say a foster parent can never attend, or just should be prohibited from attending a hearing if a parent objects?
No. They have the right to attend and be heard, so they can come, testify, be subject to cross-examination. There's a few cases on this about they can't intervene.
Right, that's a separate issue, though.
Separate issue, but so, yes, they can attend the day that they're there to be there.
But then not any other part of the hearing.
What I'm suggesting to the court is, I don't think you need to make a black and white rule, but I do think that you need to create some factors for judges to consider in terms of balancing the rights of the litigants and the foster parents. So for example, Your Honor, there might be a circumstance where the judge would say it's appropriate for the foster parents to be here for the next 2 days, let's say, of trial. This was an over the course of these 2 trials, it was 11 days of trials that this woman sat through, which is extraordinary.
Right, but you're arguing, though, that the reason why you're making this argument is because you're saying that your client was prejudiced somehow because of the foster parents being present, hearing her testimony, and then thinking, oh, wow, I didn't know all this. Now I'm starting to get nervous, and I don't want to have unsupervised, or I want my visitation to, or the visitation with the mother to change, and she started getting nervous about things based on things that she heard testimony, right? So then, really, your argument would be she just shouldn't be able to let
in an ideal
hear
world,
any hurtful or harmful testimony.
Yeah,
right?
in an ideal world, I don't think, except for when they're testifying, I don't think foster parents or guardians, except, that's why I say there should be factors, because I do think that I don't know all of the future, and there might be circumstances where it would be appropriate, and that then the judge would have discretion to allow it. But I do think as the baseline, it should be, no, we should not allow guardian. In fact, I would even suggest that it's really contrary to the child's best interest, because you have this person who's sort of independent, who's raising the child, right? And now they're maybe being infected, let's say, by whatever was alleged in the care and protection.
But on this record, we have to look at what happened here. And on Justice Tan's question as to prejudice, and I could be wrong, so please correct me. My understanding is after the foster parent attended, what changed for your client is the extras. The foster parent was doing discretionary things and then pulled those back.
They had a fantastic relationship.
The requirements of DCF at the time were still being met. So I get that that is hurtful and upsetting, but how is that legally prejudice?
How it's legally prejudice, Your Honor, is that it changed the trajectory of this case. At the hearing on the merits, the court found the mom unfit but did not terminate her rights.
Right.
But what happened after the hearing on the merits is all of a sudden it was like the floor flew out from underneath mom. She was getting, the foster mother was going with her, taking the child to her medical appointments. They were doing things, it's hard to tell from a record, but it sounds like they were friends. They were friendly with each other. She would go over to the grandparents' house, all the kids, the nieces and nephews of the child in this case were present because the sister lived upstairs.
Was it a kinship placement? It's not.
It was not a kinship placement, but what I would say is it was an ideal placement, and the foster family was doing a very good job, and mom, more importantly for me, obviously I'm representing mom, was doing a very good job of recognizing what a good job the foster parent was doing, being grateful to her, thanking her for all of her help, etc. And having her present just imploded the whole relationship. And now mom goes from having multiple visits a month to 1 visit a week. And in a supervised DCF office instead of in a natural environment in a home. And I don't disagree with DCF that, yes, they gave her the baseline. I mean, that's kind of a separate issue, is why does DCF feel like that's appropriate? I mean, that's a bigger public policy that we think that 1 visit a week for a young child is appropriate. That's beyond our capacity today, but I will say for the record, it just seems an abomination to me. So the reason why we need a full opinion, and DCF did suggest a case that I'm not saying that you should take, it was a case with the impoundment procedure. I don't think you should, I'm not saying that that's the case to follow, but what I'm saying is that factors such as what the court addressed there, I think would be extremely helpful for judges.
Well, let me ask you this, and in fairness, you probably don't have these cases, but we took a little trip around the country to see what other states do. And I think the most compelling case is in Connecticut. And I'll give you all the site, but then I'm going to tell you what it says. It's Juliet versus Commissioner of Children and Families, 351 Con 511, 2025. So breaking news out of Connecticut.
Okay.
And there, the Supreme Court held that, quote, a non-intervening foster parent's right to be heard normally will include the right to be present throughout the proceeding and to comment at the appropriate time on the evidence presented to the court. However, the court stated that, quote, trial court has discretion to modify these procedures for good cause in light of the particular circumstances of any given case, and that's at 552 note 26. Interestingly, that case cited a Massachusetts case called Sherry.
That's the one that's in our briefs.
Right,
Yep.
435 Mass at 338 note 6. So Connecticut seems to say they can, non-intervening, they can be there at all times and they can comment, and the carve-out, if you will, is that the trial court has discretion to modify for good cause.
Yes.
You know, if we were to say that, every trial court judge is going to call Judge Tan as a former juvenile court judge and
That's what I
say,
was thinking.
what does good cause mean?
Right, so that's where I think we got to define good cause. What are some factors of good cause? Like, you know, is good cause that the child is, whatever, I'm not even going to postulate what good cause.
Your argument here is that good cause, from your client's perspective, and your argument to us is that your client's extras, you know, were taken away.
Yes.
Right? So
Right.
is that?
Well, so I don't think for factors in terms of good cause, I don't think that's appropriate because only at the hearing on the merits, certainly when you do the motion to sequester, I'm saying the guardian should be, or the foster parent should be left out. At that point, the good cause doesn't apply because those things hadn't happened yet, right? It happens after the hearing on the merits.
Right, so in Arizona, it's unpublished, not my favorite, but the language I want you to think about. It's called Marin B. versus Padilla. It's a 2020 out of Arizona. And it says that a judge may limit a foster parent's presence if it is in the best interest of the child or is necessary to protect the privacy interest of the parties and will not be detrimental to the child.
Okay.
That seems better than good cause, but still pretty broad.
Yep. I want to go to the Connecticut case for a moment, since you referenced it, and I have not read the Connecticut case, but just based on what you're saying to me, I think it's the opposite of what I'm suggesting to you, which is that they are doing the same thing. They're making the burden of like, we're going to allow them in, unless there's a good cause.
I want it to be
I want it to be the other way. I want it to be, and this is, I did kind of poll, you know, we're on these groups with care and protection cases. This is happening a lot where
When you say this, what do you mean? You mean
foster parents being present for entire proceedings, particularly particularly in Hampden County. It is happening.
Ask if it's geographical.
Well, I'm only going to speak to Hampden County because A, that's where I came from, and B, that's where this case is. And I did speak to several attorneys about this issue. And so what I would like is the opposite of basically what the Connecticut case is. I'd like the exception to be that we're not going to allow them, except for the day that they're going to be there to testify, or if they show up and they want to testify. But there's a good cause reason that we might say, like it's in the best interest for whatever reason for the child.
Does Rule 17 impact this at all of the juvenile court rules?
Could you remind me what Rule 17 is?
Sure.
Of the juvenile court rules?
At the end of, oh geez, let's see.
My apologies, I should know that off the top of my head.
I don't want to misstate it, so it is at the end of, let me see whose brief it's at the end.
Oh, is that the rule that regarding DCF has to notify?
Yes.
Yes, okay. So does that impact? No, I think Rule 17, it would be the same thing. Basically, we're notifying you, there's a hearing, you have the right to attend and be heard. The foster parents then could show up, right? It gives them notice of the date of the hearing, which is another thing I think that this came about as a result. They were not notified about proceedings about the child they were caring for, and then things would happen and they would learn about it after the fact, which I don't think is fair to the foster parents. So I think Rule 17 would still apply. I think there might be a little addition that might be something like you can attend on the day that you are, you know, whatever. We might carve up some additional language, but I would say that Rule 17 applies.
I mean, I'm just looking at the note to Rule 17. It's actually at the back of Child's brief at page 128, and it addresses Sherry only. I will say, I mean, if you do have the chance to look, Maine, Missouri, Arizona, they all do it the way that you don't want us to do it. They say they're in, but you can excuse, or there's an exception. And actually Colorado, and you should look at that case, AM versus AC from 2013, Colorado says it's not a due process violation for the mom. So, and you're not really arguing that, as I understand it.
No, but in terms of, yes, I will look at the other cases, and I appreciate that. Thank you to you and your law clerks. I did want to have, I see my time is running out. The other primary argument that I wanted to address, I wanted to say in terms of fitness overall, I just want to remind the court, you know, I think juvenile court judges need to remember this, is that just even if somebody is unfit, there's no reason to terminate their parental rights. I think this is the case. A month before trial, DCF finally, why it took so long, I don't know.
I'm going to just give you a chance to wrap up because I asked you a lot of questions, but
Okay.
your time has expired.
Okay, DCF finally gave mom more time with the idea to show that she could show some parenting skills. That happened 1 month before trial. What I would suggest to the court is that judges need to know that, like, this could have been solved. Like, mom could have had the extra parenting time.
You're going to have to leave it there.
Yeah,
We
but
have
she
that
could
on
have
your
shown
brief.
that.
Thank you so much.
I would rely on my brief. Thank you.
Mr. Price for the department at 7.5 minutes.
Good morning, Your Honors. May it please the Court, Matthew Price on behalf of the Department of Children and Families. The Department is asking this Court to affirm the decision of the lower court that terminated mother's parental rights. It was not an abuse of discretion.
Are we reviewing this question about the foster mother's attendance and the denial of the motion to sequester for an abuse of discretion?
I think the denial of the motion would be abuse of discretion.
Let's assume for the sake of argument that I thought, and by the way, I don't know what I think, but that I thought the judge should have waited and kept her out until after she testified, and then once she was done, let her in, the foster mom. Assume that premise. Would mom then need to show prejudice?
Yes.
Okay. And the fact that the only thing mom cites in her briefing today is that the so-called extras that foster mother was giving, she then stopped giving, that's insufficient for prejudice?
Yes.
Do you think that there should be a rule or some checklist, if you will, of what a judge must consider in order to allow a foster parent to come in for the whole hearing? Or do you think 119 is carte blanche and there need not be any carve-outs or exceptions?
I think that the judge followed the law.
Yeah, but that's not what I asked you. Think every case.
Yeah, I think there's room for exceptions for the judge to act, but
And what would the exceptions be based on?
Well, I think considering the facts of this case, what would qualify for a motion to sequester? And that would be a risk of the integrity of witness testimony, which wasn't an issue here.
So best interest of the child, not a factor?
The best interest of I think it would have to be a case-by-case situation.
I guess that's what I'm asking you, right? If we're looking to give the juvenile court judges some guidance as to when to do this and when not to do it, I understand what the issue is on the motion to sequester and the integrity of the testimony, but these are care and protection termination of parental rights cases. So are we looking at the child's best interest? Are we looking at what we often have in these cases, very, very sensitive information about the parent? Are those considerations or no?
No, unless on some kind of exceptional circumstance, I would say. The law intends for foster parents as one group to participate in hearings. And recently, with the new Foster Parent Bill of Rights, there was an addition that even includes all, that they need to be notified of all hearings. It seems, and with the legislature's language as far as moving towards more inclusion rather than less inclusion, there have notice to be present and to be heard. And I think that those are not just be present to be heard.
So what if, I'm going to use the language from the Arizona unpublished case, what if the mother had said, it's not in the child's best interest, it is necessary to protect my privacy, and it will not be detrimental to the child? If the judge made those findings, could the judge limit foster parents' participation notwithstanding the Chapter 119 provisions?
Yes, I think she could. That wasn't this case.
I know. I asked you a hypothetical.
Yeah, no, I understand. But I think that the reasons that she gave did not amount to what needed to be protected. And I think it's Adelaide that talks about the focus being on the privacy of the child. And that's what was being considered and protected. I don't think that mother showed prejudice as a result of how everything played out in terms of harm that she suffered. She didn't have extras, and the court made a finding.
Talking about Adele, is that the case?
Yes. Okay. Yeah, sorry. The court made a finding that it wasn't the mother's background and history that caused the rift. It was the mother's statements that essentially were alleging neglect by the foster parent that was the cause of the rift. And the judge acknowledged that the foster parent's sort of withdrawal from their previously good relationship was understandable in those circumstances.
That was with the incident where there was pictures sent of the child wearing glasses belonging to the...
I believe so. There was an incident where the child fell out of a bed, and so this is what sparked it, not sensitive material about the mother that caused the foster parent to withdraw. If there's any further questions, I'll rest on my brief.
Thank you. Attorney Smith?
Good morning, members of the panel, and may it please the court. My name is Laura Smith on behalf of the appellee child. The now nearly 7-year-old child asks that this court affirm the termination of the appellant's parental rights to allow a child who was in foster care for 5 years to be free.
Can I ask you a question?
Yes.
Not related to the specifics here. I note that you're from CAFL.
Yes.
So is this happening a lot, what happened here?
Foster parents attending trials? Yes, they do attend trials.
And what is the position of CAFL at the trial court on child's behalf the same as your position here?
I can't speak to what all of CAFL's position is. Our position here is that the statute is clear, that it's a plain language interpretation that the trial court went with. We would say that was an error.
So does there need, as Mother's Counsel suggests, does there need to be some guidance from this court to the juvenile court about when and when not to allow a foster parent, specifically when there's a motion to sequester, to be in?
I would argue no, Your Honor, because the statute is clear, and it seems more like the cases that Your Honor referenced earlier, that the general rule is that foster parents come in. The only time there's these other jurisdictions have these carve-outs, I would say our carve-out is the motion to sequester, which would be in the judge's discretion.
And that's really just to preserve testimony. That really doesn't go to child's best interest, detriment of the child, privacy of the parent.
That's true, Your Honor. However, in a motion to sequester, or perhaps another type of motion by a trial attorney, the judge could consider those other factors. There's nothing that prohibits a judge from removing someone from her courtroom, for instance.
We don't have any cases that say that, do we? Motions to sequester are kind of, I'm going to call them vanilla.
Yes. Adoption of Jacob discusses it briefly, where
That was the grandparents,
the
right?
grandparents, correct.
They weren't foster parents, and I believe we held that they did have a statutory right of access to the C&P under 11929D. The right to be heard was to ensure the judges have all relevant information about the child, and the best procedure for exercise of this limited right in any given case is left to the discretion, and they quote Sherry.
Right.
So I read that case as more of a notice issue than the substantive issue that we have here.
Yeah, I would agree, Your Honor, that the case is different. It doesn't address the right to attend specifically, neither does adoption of Sherry. However, the grandparents in Jacob were the foster placement, which is why the judge did allow them to be present. They also were represented by counsel, so the days that they weren't present for the hearing, they had counsel that were present and could hear what was going on and then inform them, whereas our foster parents in our cases are typically unrepresented by counsel, so they wouldn't be afforded that same protection.
Do you know, are you aware, I know Mother's Council has said that this is happening a lot where foster parents are listening to or sitting in on the trials. Do you know if, and it's okay if you don't, if there are objections by, is that over a party's objection?
At times, yes. I know myself, I was a trial attorney for 5 years prior to being an appellate attorney, and I objected. So I can't tell you statistically, the numbers of how it's happening, but in this case, it was over objection. However, counsel's argument really is to rewrite the statute and perhaps the entire statutory scheme, because the legislature likely knows that these cases are, contain very sensitive information about parents and children, which is why the courtrooms are closed. But they also
But there are occasions, though, you would agree, especially, CAFL represents, as you did, I'm sure, both parents, or parents sometimes, and sometimes, a child, right? And so if you're representing a parent, I could see you might want to object to the foster parents, depending on the case, being present, right? So is there not, you could foresee there being occasions, right, where you would want, as an advocate, and maybe the judge, to have the foster parent not be present.
Yes, Your Honor, of course. And I would say that that's when the trial attorney files the motion to sequester, or another motion, however they want to title it or stylize it. But it's the trial judge's discretion at the end of the day whether what is argued in that motion meets their discretion for removing somebody from the courtroom. And I would say also that the appellant in this case was not prejudiced, because what information was gleaned from the trial was, and the reason that the foster parent gave at trial under testimony as to why those quote-unquote extras were stopped was because of two reasons. The first reason was the photograph that she had sent to the appellant, and the appellant then used against her. She raised the specter of wrongdoing by the foster parent, which would have had to be addressed by DCF at some point. So whether she found that out during testimony at that second trial, or, the first trial, or whether that was raised by the DCF worker during a monthly home visit, that was going to be addressed. The other basis was that the appellant was seeking placement with an uncle out of state, which would require an ICPC for placement. Again, the foster parent would have become aware that the department was initiating an ICPC with another state. So she would have understood this information regardless. And the court didn't terminate the appellant's parental rights on that basis of losing those extras, having that extra time with her child. She terminated parental rights because of the appellant's actions and inactions, her own behavior. And the court did find a bond between the child and the appellant, and therefore issued post-termination and a post-adoption contact between them. So the appellant wasn't harmed, and the legislature likely would need to rewrite the statute or provide an extra carve-out, and otherwise it would be in the trial court's discretion. I see that my time is approaching. If the panel doesn't have any further questions.
I don't see any.
The child would just ask that this court affirm the decree to terminate the appellant's parental rights. She failed to remedy the conditions that necessitated the child's placement in foster care, and the child's best interests were served by issuing a decree. And
Thank you.
thank you. We rest on our brief.
Appreciate that we asked you a lot of questions today, and we very much appreciate your patience with us and doing your best to answer cases that you had not read before.
Thank you, Your Honor. Thank you, it's good, actually.
Our last case this morning is RENITA K. Johnson versus George J. KERAMAS and another, docket 24P1339. Docket indicates it's partially impounded, so counsel, please comply with that order. Still morning.
Good morning, Your Honors. Steve Grant for the appellant George KERAMAS. May it please the court. There are a number of issues, as you...
Well, 11, according to your brief.
Yes, it was a rather complicated case with a number of issues. I would say probably the most significant one today would be what we call an abuse of discretion on the lower court to default my client for willful disobedience of discovery orders. Keene versus Brigham and Women's, for example, says that in order for such a drastic sanction to occur, there has to be bad faith or indeed willful disobedience of such an order. Here, in this case, my client, far from bad faith, demonstrated throughout the case painstaking efforts to in good faith comply.
Did he produce all the bank records when they were requested?
Yes.
Why did Johnson have to subpoena the ones in Florida?
To which account are you referring to, Your Honor?
She had to subpoena the bank records in Florida because your client didn't produce them. Miss Johnson has a number of records that my client was unable to get. At one point, I was ordered by the court to get what I could for these SunTrust records. And I was ordered to document my efforts, and I did document my efforts, and it's all in the appendix. And they did not have the bank statements available. There's actually an email.
They in that sentence?
The SunTrust Bank. I was in communication with them trying to obtain these records. I finally got an apology from one of the reps for the delay, and he sent me 10 basically nominal documents. There was a signature card in there. We were unable to obtain them, and the court was satisfied with my efforts at the time, anyway. So...
Did he appear for his deposition?
Yes, absolutely.
The first one? The first time?
That was before I was on the case, Your Honor. I don't ever recall there being an issue with that. We attended a two-day deposition at counsel's office. Yeah. I do notice in my brother's brief that he stated he didn't appear for his deposition, but indeed he had. And certainly the lower court took no didn't have an issue with that. So basically, the discovery order stems from an initial order for a motion to compel. At the time, we stated we had we've given all documents in our possession, custody, and control. 2 years later, the appellee filed a motion for sanctions, saying we weren't in compliance with that order. At the time, again, we emphasized we had given them everything, including a final trust account, which included over 4,000 pages, which included bank statements, canceled checks, and so forth. But now the issue became specifically with regard to one clause in the order regarding document requests. Now they wanted any and all documents which relate to the present whereabouts of the proceeds received by George KERAMAS on the sale of the trust properties. There was certainly no dispute that my client, certainly he didn't, it's misleading. My client never took the closing proceeds. After the sale of 3 properties, $350,000 went into the trust account, and then my client paid himself a portion of his owed trustee fees with that money. And there was no dispute about that. We gave a document showing that the money was transferred to my client's account. But now the appellee was saying, we want to know where they are now, 2 years later, the present whereabouts, which we contended was inconceivable. So that's, but still the court said, okay, you have to try and do that. And that's when I went to SunTrust Bank, trying to get bank statements to that effect, and I couldn't do it because they just didn't have them. Again, they only gave me those 10 pages. So when push came to shove, we said, look, we've given you all the documents in our possession, custody, and control. We stated, my client, by affidavit, full compliance, under oath. Then the third or fourth judge on the case, Judge Karp, came aboard, and then my brother filed a supplement to his motion for sanctions, now saying, again, we want to know the present whereabouts of the $350,000 and the present whereabouts of $256,000, which was, first of all, we argued that's not even in the jurisdiction of the court. These were personal funds of my client, which stemmed from the sale of stocks, and that money was transferred into a joint account by the settler, James, and my client. But at the end of the day, the judge, yes, ordered that there be accounting for both monies. My client, and if you haven't seen it already, I would turn your attention to RA 3706. My client submitted an accounting regarding the $256,000. It took him, under affidavit, he stated it took him 143 hours to do it. It was 83-page single-space accounting, noting every single transaction of where that money went. And then, with regard to the $350,000, we informed the court, we exhausted our efforts on that, and accounting just isn't possible. So far from willfully disobeying an order, my client, again, repeatedly and consistently throughout the case, showed good faith efforts to comply with these orders, which we disagreed with in the first place. Any other questions on the default? I know there are a number of issues. I guess the next issue I'd bring with regards to my client's motion for alternate security. Johnson was awarded summary judgment on a breach of contract.
Why does this matter after final judgment is entered?
Well, this was a separate, why does it matter, Your Honor?
Yeah.
Well, we have the right to appeal from a summary judgment, if I'm not mistaken, Your Honor.
You have a right to appeal from an allowed one, not a denied one.
The court ruled against my client.
Yeah, but why isn't it subsumed in the final distribution?
Why isn't what subsumed?
This alternate security argument.
Well, for starters, we disagree with the final assessment of damages, where these monies were rolled into that. That's what you're asking. But because in that order, the judge allowed my client to get a credit for the $350,000, which he was unable to pay at the time, but the judge added to that order, ordering the termination of the trust and that the trust properties be sold. That this totally exceeded his authority. The MUTC is clear about that. It runs totally counter to the trust and to the settler's intent, which was to be selling real estate property, investing in real estate. I guess moving on to another issue is this issue of the automatic stay, which Johnson completely violated a day after judgment entered, and within, before an execution issued, she withdrew over $1 million out of the trust account, ordered monies being held by New England Realty Associates, which had some unsold stock sale certificates, ordered them,
Wasn't the discovery issue resolved by the single justice in 22J19?
I believe that was a summary. I believe that was an appeal. Which order are you referring to, Your Honor?
The one you're talking about. You asked to stay post-judgment discovery, right?
Yes.
And then when that was denied, you went to a single justice, Justice Singh.
Yes, that's right, Your Honor. And that
Why? And it was resolved there.
understood. Next, I guess I'll turn to my motion to dismiss the appellee's motion to amend the complaint, again, referring to what I alluded to before. Particularly, there were 2 counts for conversion in that complaint. The statute of limitations barred those counts. It was well after 3 years of the alleged conversion. And on top of that, Ms. Johnson was aware of the issue in question. She was basically saying that my client converted, through these wild, unsubstantiated allegations, that my client converted funds from the settler, forging his name and impersonating him and so forth, and essentially took money and it took these NERA funds wrongfully, and basically saying she was, as an heir, she was entitled to these monies, but we say she didn't have standing. Only a personal representative can seek to garner these funds, and only the probate court has jurisdiction over these matters. They have exclusive jurisdiction over, first you have to determine heirs and testacy before you can bring such a count. Any other questions, Your Honors?
Don't see any.
All right, thank you.
Thank you very much. Attorney Farber.
Good afternoon, Your Honors, and my name is Peter Farber, and I represent the appellee, RENITA Johnson. 11 years ago, this very month, the party's father was admitted to a hospital in Florida. 2 months later, he was 86. 2 months later, he died. My client attempted, after that, for the first year, to obtain information from her brother, her older brother, as to what happened to 3 parcels of real estate that were held in trust for both of them. It was clearly announced or set out in the trust that they were the 2 beneficiaries. Mr. KERAMAS, the brother, would not provide that information. 4 years ago, this lawsuit was commenced. The docket is 57 pages. After judgment entered in October of 2021, another 4 years has gone by and brings us here today. The arguments raised by my brother, Mr. Grant, I think are absolutely without merit. I've addressed them all in my brief.
I don't think that's
Ms.
right.
Johnson.
There's several that you haven't addressed.
Pardon me?
There's several arguments you have not addressed.
You're correct, Your Honor. And as I was
Just told us you
preparing
addressed all of them, and now you're told you have not addressed all of them.
I don't think, I would comment in this way on those. I think that they are intertwined with what I would call the major arguments, the major points. I did not consider them worthy of separate.
Well, he argues that you don't have standing to bring counts 4 and 5, and you talk about the ability to bring this suit in Superior Court, but you don't explain why she had standing.
Yes. Your Honor, the Superior Court was the court in which this case was filed.
No, I got that part. That's in your brief. Why you don't talk about standing?
Why what?
Standing. He says they don't have standing.
I don't understand the standing argument at all. It wasn't raised below, that's for sure.
Well, that's the sort of thing that would be helpful if you put in your brief.
Well, I mean.
You don't address the alternate security argument either.
I think the Superior Court has plenary jurisdiction to decide through its equitable powers to decide the division of personal property, trust property, division of assets, trustee fees, and eventually termination of the trust. And this argument that only a probate and family court has jurisdiction, I think has no basis in the law, and I know of no case law that holds that. So for that reason, I didn't address it in any more.
What about there's a claim there was an error in addressing damages at pages 55 through 62, and you don't address that at all.
Now, the damage, I'm sorry, Your Honor.
Error in assessing damages.
All right. So
he argues that the trial judge erred in the assessment of damages at page 55 through 62. That's several pages, and you don't address it at all.
Yeah, because I think it's very obvious when you read Judge Dressler's decision, all right, that he went through count by count with figures that were literally to the penny, all of which were set forth in the second amended complaint, all of which therefore were admitted because of the default. And so he was writing on a slate that had been set out for him by admission of the parties. There was, and the actual, there was no motion at the time, a post-decision motion of any sort that Judge Dressler had misstated the figures or in any way had erred in his decision. He addressed each and every count fully and very carefully. I mean, he awarded the amounts that were set forth in the complaint and were admitted, and he gave credits so that he wasn't double, allowing for a double.
This is the sort of thing that should have been in your brief.
That what?
This should have been in your brief.
I'm sorry, I can't hear. I'm sorry. Okay.
Never mind.
So I would rest on my brief other than pointing out a couple things. Mr. KERAMAS acknowledges that his primary duty as trustee was to protect the trust assets and carry out faithfully his fiduciary duties. And I think it's clear from the record that he did not do that. And 5 different judges of the Superior Court carefully reviewed his allegations as to whether he had complied with his duties, and each and every one found that he had utterly failed in that respect. He claims that, Mr. KERAMAS claims that the judge forced a premature liquidation of the trust assets, which were the 5 parcels of real estate, but Mr. KERAMAS himself liquidated the first 3 parcels and was well on his way to liquidating the major income-producing parcel, which was the shopping center, the Timber Hills Plaza property in Florida, and would have done so if my client had not discovered that the property was under a purchase and sale agreement and was due to close within a month of when she found. So his argument that the judge improperly destroyed the income potential for the trust, I think was contradicted by his own sales of property or his attempted sales.
Mr. Farber, you say in your brief that Mr. KERAMAS violated several court orders that led to the Rule 37 sanction. Can you outline for me what orders he violated as far as document production or attendance at depositions?
Well, he eventually did attend a deposition, so that's not really a matter at this point. He did not produce documents for several years. In the end, he did do his accounting. He did produce the accounting, but he was claiming $770,000 in trustee fees, but not a shred of proof to justify that figure. And he wouldn't have deserved that case based on how he conducted himself as trustee. So I think it was certainly within the judge's discretion not to award him any fees. So he claims again and again that he exercised the utmost good faith in carrying out his duties, but again, it's clear from the record that he did not. And I'd just like to point out that the court, there's 3 documents or 4 documents that I think tell this whole story, other than what's in my brief, and I could just recite them for the record. They would be the...
Are these in the appendix?
Pardon me?
Are these in the appendix?
Yes, they are, Your
And can
Honor.
you give us the record sites, please?
They're all in the appendix. I can just cite the pages.
Can you tell us where they are in the record?
Yes. So the first is the first motion for entry of default judgment. No, the first is a motion for sanctions, 45, paper 45 in the docket. These are all in volume 2 of the appendix. This is found at page 336 and the following pages. The next document is the discovery compliance order that was issued by Judge Karp on April 2nd, 2021, and that's in volume 2, beginning at page 802. Then there's a renewed motion for entry of default judgment dated July 2nd, 2021, and that's at volume 2, page 930. And finally, a reply memorandum on behalf of Ms. Johnson in volume 2, beginning at page 954. And as to the last one, I just want to point out there's an exhibit, and Mr. Grant referred to it today, an 83-page, single-page, statement that apparently Mr. KERAMAS spent 100 and some hours preparing, and this was in response to our claim that he had never provided the evidence or the documents as to what he did with the $256,000 plus that he received when he sold the shares in New England Realty. And he went through, and it's almost laughable because he says, I spent $8.82 at Amazon. I spent $4.36 at a drugstore, and on and on and on and on, 83 pages. But he never, he, meaning Mr. KERAMAS, never addresses where did the money go that you dispersed to yourself? It didn't come out of this account and wasn't used to pay Amazon. And you also paid, I think it was $51,000 to his wholly owned corporation, Acriva, $100,000 to Acriva. In other words, the bulk of the money he never addressed. He just skirted right by it and wasted everybody's time with this, oh, I don't know the present whereabouts of the money I paid to Amazon on a certain date. And I think that's been this whole case. is Mr. KERAMAS believes he's above the law and that he made no mistakes here. He says at the beginning, and he says it now, his father told him to sell the stock in New England Realty, told him to sell the Mercedes, keep all the money from both, and yet Mr. KERAMAS was defaulted on the second amended complaint that challenges all of those statements and says, and there's no evidence to support any of them other than the self-serving statements of Mr. KERAMAS. So in conclusion, I'd just like to ask the court to address the matters that are been raised on appeal and make a finding that the judge was well within his authority under the law and the facts to enter the judgment that he did. Thank you very much.
Thank you, gentlemen. The case is under advisement. That concludes today's session of the Appeals Court. I'd like to thank the court staff, in particular the court officers, the clerk's office, our law clerks, and our wonderful timekeeper. We are in recess.